we're talking about filing a bankruptcy case before the divorce decree has been entered. In other words, while the divorce is still pending. It's a little bit different, of course, after the divorce. If you file the bankruptcy, then it doesn't really affect the divorce much. But let's bifurcate that into two pieces. First, the divorce proceedings are in progress and one of the parties files a bankruptcy petition. Anytime someone files a bankruptcy petition, whether it's under Chapter 7, 11, 13, doesn't matter, just the act of filing the petition triggers a stay. The debtor doesn't have to do anything else, so it's called the automatic stay. In law, stay says stop. Whatever stayed has to stop immediately. And in this context, what stayed or stopped is all action by creditors against the debtor, against the debtor's possessions, and against the bankruptcy estate that's created when the debtor files that petition. Well, there are some carve-outs in the bankruptcy code that say, well, the automatic stay doesn't apply to a couple of other things. And they're listed in Section 362B of the Bankruptcy Code. 362B1 lists matters that are associated with, or AB1, I should say, divorce. So if the bankruptcy has been filed, it does not stop any proceeding to determine paternity. It doesn't stop any proceeding to determine child custody or visitation. It doesn't stop any proceeding to determine domestic support obligations. It doesn't stop the dissolution process itself, and it doesn't stop any proceedings regarding domestic violence. But there are some things associated with the divorce that are stopped. Certainly the division of assets. And you might wonder, well, why is that not being stopped? Because the assets are part of the bankruptcy estate. And so all actions against the bankruptcy estate have to stop. So what that means then is one of the key things in a divorce is the division of assets. That can't be done while the stay is in progress. And I did a motion for relief from the automatic stay for a man who had gone through a divorce and everything had been taken care of except for the division of assets. And his ex-wife filed a bankruptcy case. And after a couple of years, he decided he couldn't make ends meet. He needed to get his half of the assets. So we filed a motion for relief from the automatic stay and asked the judge to lift the stay for the limited purpose of going back to the family court and getting the division of assets completed. And the judge granted that motion. He went back, he got the division of assets taken care of. But that's certainly something that does get gummed up as a result of the filing of the bankruptcy case. So that is, I suppose, the key thing that is that affects divorce, the filing of the bankruptcy. One thing that doesn't get affected is the obligation to pay domestic support. If that's already been established, then a garnishment of wages that is specific to domestic support is not considered a violation of the automatic stay. And so that ex-spouse that's having to pay domestic support is going to have to keep paying domestic support in the bankruptcy. I might add that the obligation to pay domestic support is not dischargeable in any chapter of the Bankruptcy Code.